Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying this high-quality legal education content, please remember to subscribe to increase your legal knowledge. For today's case, we are dealing with a situation with a prison guard who has beaten up a prison inmate and caused damage and harm in the case of William James Dean versus Johnny Johnson. In this case, some prison guards did some things to a prisoner that seemed a little bit excessive, to put it mildly, and the prisoner would like to sue, and they'd like to claim qualified immunity, among other things. So the court will analyze this case coming out of North Carolina and try to determine whether or not this was excessive force or not. Let's get started with this. This appeal concerns two use of force complaints against Dean by correctional officers Charles Hobgood and Johnny Jones on December the 12th of 2015, while Dean was serving a prison sentence at Central Prison in Raleigh, North Carolina. We begin with the first incident, which occurred while Officer Hobgood was escorting Dean back into his cell after a visit to the prison barber. During that walk, Dean concedes he headbutted Officer Hobgood, causing him to fall. So the prisoner headbutted the prison guard, and the prison guard fell to the ground. It didn't go well at that point. Yeah. According to Dean, he promptly was subdued by a second officer who arrived on the scene. Dean ended up lying on his back with his hands handcuffed behind him, while Officer Gibson, on top of him, pressed his knees into his chest. At that point, Dean attests, while he was still restrained and non-resistant, Officer Hobgood got to his feet and administered one long burst of pepper spray to his face, lasting over 3 seconds and partially blinding him. So his claim is, after I was subdued and under custody and I was no longer resisting, that was when they decided to pepper spray me in the eyes. Basically out of revenge, not because they needed to get me under control, but because they wanted to give some retribution for the headbutt, which seems like a bad decision. But that doesn't necessarily give the guards the ability to do anything they want legally, right? The second episode began after 12 other correctional officers arrived at the scene in response to the call for backup. 2 of those officers, one of whom was Sergeant Jones, held onto Dean handcuffs' wrists and began escorting him towards a nurse's station for decontamination. According to Dean, during the escort, Sergeant Jones twice pushed him into a sliding door without provocation. One of those incidents can be seen on video. So there's some video of this apparently, which is always helpful. So we have some things to back it up that he was being pushed in without resisting. So that's good. As the escort continued, Dean stated he feared for his well-being, panicked, and headbutted him in the face. He likes the headbutting, man. Maybe we got to learn how to use our words rather than the headbutting. That's the real key. I wonder if it has anything to do with why you're in prison in the first place. That'd be good. What's the probability the reason he's in prison in the first place has to do with headbutting? Yeah. Anyways, the video shows Sergeant Jones surrounded at this point by 10 other officers respondingly by pushing Dean up against a nearby wall. And then on Dean's account, Sergeant Jones told the other officers to get him in there, and the officers pushed Dean into a nearby janitorial supply closet out of the range of the cameras. Dean, then still handcuffed, landed on the closet floor, and there he claims he was maliciously beaten by Jones and the other officers. So, after this incident, he was hauled into a place the cameras couldn't see, and he was beaten for his troubles. So, that might have happened. Dean's injuries were severe. The discharge instructions from Wake Medical Center, where he was treated, stated that Dean suffered a contusion of his face, an abrasion of his face, a closed fracture of his nasal bone, and a subconjunctional hematoma. Week after the incident, Dean could not see anything out of his left eye. He later underwent surgery. So his beating was pretty severe. It caused partial blindness, partial temporary blindness, some broken things, a hematoma, some other things. So he got the crap beat out of him pretty hard. And then he decided to file a 1983 cause of action against the people that hurt him. So he'd like to get some civil remedy for this excessive force against him. The district court agreed with officers on the merits, holding that Dean could not establish an Eighth Amendment violation as a matter of law. So the district court said, this is totally fine. The Eighth Amendment would be the cruel and unusual punishment one, by the way. That's why it's the Eighth Amendment. So he said, I have a cruel and unusual punishment. District court said, we don't know what you're talking about. What cruel and unusual punishment? All right, that's what the district court said. As the court recognized, the Eighth Amendment excessive force claim turned on whether the officers applied force with sufficient culpability of mind. That is, malicious, and in order to inflict pain, and not for a permissible reason, like protection of safety. So they only get trouble for the Eighth Amendment if they're doing it with intent. So if they just do it without intent, it's fine, but if they do it with intent, not so much. The district court granted summary judgment to the officers on the merits of Dean's excessive force claim, finding as a matter of law the officers had used force for a permissible purpose of protecting the officers' safety. And so we're going to review that de novo and figure out whether or not that's true. So the district court said, the officers dragging you in this closet and giving you partial blindness and hematoma was totally cool because they're trying to protect themselves. All right, so what does the Court of Appeals have to say? A court may grant summary judgment only if taking the facts best to light for a non-moving party. No material facts are in dispute, and the moving party is entitled to judgment as a matter of law. In other words, we, like the district court, must review facts in light most favorable to Dean, drawing all reasonable inferences from his favor. So the trial court trial court didn't dismiss on qualified immunity. Ultimately, they dismissed on a summary judgment. So basically, the trial court said that if everything that Dean says is true, he still loses. That's the right standard. So with all the facts, even if everything he says is true, he still loses. So the Court of Appeals is in the same position. They have to assume everything he says is true and whether or not he still loses. That would be the appropriate standard for a summary judgment, right? If everything you say is true, do you still lose? If not, we'll go back to trial. So we're going to assume everything that the prisoner says is true. It might not be. That's for a factual finding. But for the moment, we'll assume it's true. The legal standard that governs the Eighth Amendment excessive force claim is clear. An inmate's claim of excessive force involves objective and subjective components. The objective component measures the nature of the force employed, asks whether the force was sufficiently serious to establish a cause of action. This is not a high bar, however. De minimis or trivial force is not enough, but anything more will suffice. The more demanding part of the test, and one which the district court appropriately focused, is the subjective component, which asks a single question: whether the officers act with sufficient culpability of mind. So the officers have to act in a deliberate, willful way. They have to be trying to do this out of malice. For example, revenge would be an example. So if they were doing it with that rather than a protected reason, like ensuring the safety of the prison or, ensuring compliance or things like that. So were they doing it for legitimate reasons or because they were pissed off? That's what we have to figure out. The more demanding part of the test, and the one in which the district court appropriately focused, is the subjective component, which asks a single question: whether the officers acted with a sufficient culpability of state of mind. Whether an inmate can establish that impermissible motive turns on whether the force was applied in a good faith effort to maintain or restore discipline, or maliciously and sadistically for the very purpose of causing harm. So this was a move of a sadist. Yeah, okay. As we've explained, officers employ force in good faith and thus permissibly when they're motivated by an immediate risk to safety or threats to the prison order. But they cross the line into impermissible motive when they inflict pain not for safety or prison discipline, but to punish or retaliate against an inmate for his conduct. On summary judgment, then, the inquiry under the subjective component boils down to whether a reasonable jury could determine that the officer acted with malice, appropriately applying force punitively and for the very purpose of causing harm. Because direct evidence of motive or intent may be hard to come by, the Supreme Court in Whitley established out 4 factors in which they can infer a subjective intent. And those 4 factors are the need for the application of force, the relationship between the need and the amount of force needed, so like proportionality, basically. Did you need to use force? Did you use a proportional amount of force? The extent of any reasonably perceived threat that the application for was intended to quell. So what was the nature again of the threat? And the effort made to temper the severity of the response. So was there anything done to mitigate the harm? So those are the 4 factors you can look at that will help you figure out if there's subjective intent. What was in the mind of the officer of the prison? All right. Under the correct standard, we have no difficulty concluding, as we have before, that a reasonable jury could find a sustained blast of pepper spray directly into the face constitutes something more than a de minimis force, especially when it leads to the kind of injuries that we've talked about. Officer Hobgood argues that because the officers intended to decontaminate the eyes after the fact, the force itself becomes de minimis, and we disagree. What happens after the force is employed is irrelevant, which it is. So Whether or not we used excessive force happens at the time we use the force. So we might have tried to mitigate afterwards, but the force has already occurred. So the relevant question is the amount of force at the time it was used. So the amount of treatment might go to the ultimate damages, right? Because if you mitigate the damages, but it doesn't go to the initial issue of liability. That brings us to a subjective component, and whether Officer Hobgood used force in good faith efforts to subdue Dean and protect officer safety, or maliciously to punish Dean. Applying the first of the factors, the need for force, the proportionality of the force, and the use of force and threats to officer safety, the district court held that only one inference could be drawn, that Officer Hobgood pepper sprayed Dean because he feared for his safety and then asked for a permissible motive. So the trial court said, well, based on the evidence, I think that there's only one inference that could be drawn, that Officer Hobgood did a good and proper thing for good and legitimate reasons. The problem there was, the district court applied the wrong legal standard. The problem with the analysis is that whether Hobgood's use of pepper spray was clearly necessary to respond to a threat of safety turns on material questions of fact that are sharply disputed by the parties. On Officer Hobgood's account, to be sure, the pepper spray was necessary to protect against the threat posed by a resistant Dean, still largely unsubdued and grappling on the ground with Officer Gibson at the time force was used. But we must view the record in the light most favorable to Dean, because of the standard we're in. That's right. So whether or not we can get to trial, and what the trial will prove, is a whole other set of problems. But on a summary judgment standard, we assume everything in the light against the moving party, or against the person who's asking. So the prison is asking for summary judgment. So we have to assume everything the other side says is true. That's the entire point. If everything he says is true, does he win? All right. So we have to view the record in the light most favorable to Dean. And Dean's account has him fully subdued and non-resistant, lying on his back with handcuffed arms beneath him, and his officer kneeling on his cheek with hot goods pepper spraying into his face. A reasonable jury crediting Dean could draw inferences from these factors. The need for physical safety and order was not so self-evident, it excluded the possibility of motive. So the Court of Appeals says, well, you just got the wrong standard here, which they did. They got the wrong standard. They said, well, if you look at the evidence, all the evidence together, then there's only one inference to be drawn, that they used it for legitimate reasons. And the Court of Appeals says, no, wait a second. You're giving credit to the officer's testimony. Now, you really can't do that here, because you have to assume everything Dean says is true, unless it's palpably absurd. And there's no reason to think it's palpably absurd, because there's some videotape and there's some documentation of the damages, so there is enough to suggest that what he's saying is true. Now, whether or not what he's saying is true is, of course, a question of fact for an eventual fact finder, such as a jury. But at this point in the case, we have to assume everything Dean says is true, that he really was pepper sprayed when he was already handcuffed, with the knee on his chest for 3 seconds into his eye, and that he was drawn into a hallway closet and he had the crap beaten out of him. So the district court looked at the facts and said, well, I believe and credit the officers. It's like, no, you can't really do that at this stage of proceedings. You have to actually go forward with some fact finding. In reaching the conclusion the district court did, the district court appears to have made 2 mistakes. First, it seems to have found as a matter of law that Dean remained a threat to the officers while he was lying on his back. And that was so, the court reasoned, because even on his account of the episode, the officer was attempting to hold his knees to his chest, his legs were largely unrestrained. But that misunderstands the sworn statement, in which Dean describes a different scene. Dean is lying on his back, with his cuffs arms beneath him, and Officer Gibson's on top of him, with Officer Gibson's knees driven into his chest. And a jury crediting that account could find Dean was entirely restrained when he was pepper sprayed, posing no threat. The jury can look at this and decide which of them they think is telling the truth, which will be informed by physical evidence, which will be informed by medical evidence, which will be informed by videotapes and so forth and so on. And the jury can make that decision. That's what juries are for. Second, and more fundamentally, the district court erred to the extent it suggested. A jury would be required to deem Officer Hobgood's use of pepper spray necessary and proportionate so long as it came almost immediately after the headbutt. We appreciate that the decision to use force often involves a split-second judgment made under tense and difficult circumstances, and that due deference is owed to correctional officers' effort to protect their and other safety. But we've also made clear that justification for using a protective force expires at the very moment the threat is neutralized, which you might have to get into whether or not that was determinable by the officer, whether or not they could make that determination based on the facts and the situation. But as a matter of law, that's right. So again, that's up to a jury. When did it end? Could they determine that? What was their motivation? Did they have malice in their hearts? And so forth and so on. That's what juries are for. Go ask them what the answer is. Recognizing our case law relying on such evidence in Eighth Amendment cases, Sergeant Jones raises an alternative argument. Even if the officer's statements could prove or help to prove malicious intent, he contends, his alleged statements do not. Here, shouting, "You effed up" at Dean while beating him does not evince more than a neutral truth. So Dean says, "You were beating the crap out of me," while yelling, "You effed up." And the officer says, well, even if I was doing that, that doesn't evince malice. It's just a neutral truth. It's not malicious. It's neutral. Okay, it's neutral that Dean did in fact mess up by head beating two officers. But a reasonable jury can come to a different conclusion. A reasonable jury would not be compelled as a matter of law to endorse that particular reading. I suppose a jury could say that was just a purely factual statement and doesn't indicate any malice, but, ask a jury what it means. That's what they're for. A jury crediting Dean's account might also find the alleged statements evinced a different truth. That Jones was angry, for example, and justifiably so, and the use of force might have been punitive. Yeah, a jury could make that determination. They could say it's neutral and just a statement of fact, or they could say, no, not quite so much. That's what juries are for. Whether Sergeant Jones made the statement in question, and if so, what it says about his state of mind, is for a jury to figure out. And so the district court erred by taking this away from the fact finder. Because we conclude a reasonable jury could find the officers violated the Eighth Amendment rights, we must now consider whether or not they're entitled to qualified immunity, everyone's favorite subject. So now let's consider the issue of qualified immunity and whether or not these officers get qualified immunity for all this stuff. The officers argue that because there is no published circuit precedent finding Eighth Amendment violation where force is used shortly after an inmate has assaulted an officer, Dean's right to be free from Officer Hobgood's use of pepper spray or Sergeant Jones' blows was not clearly established at the time of the incident. So they say, well, we might violate his rights, but it wasn't clearly established, which of course, as a general proposition is a pretty good argument because we cover enough cases to show that to be true, right? First, however, the court says, it was clearly established. So nice try, but no. It was established in 2015, and for many years before that the inmates have a right to be free from pain and inflicted maliciously in order to cause harm rather than a good faith effort to protect the officer's safety or the prison order. And our case law has long made clear that correctional officers cross the line when they use force to punish an inmate for intransigence. So this is not a new idea. You can't just punish people. That's the Eighth Amendment, cruel and unusual punishment, right? And it's not your job to punish people in prison. Your job is to keep them safe, and if they misbehave, you can use force as necessary, but not for the purpose of punishment, not for vindictiveness. And that might have been what you're doing. So, yeah, the case law is well established enough. So, no, on the qualified immunity thing, no. And as we've explained before, that clearly established Eighth Amendment principle was enough by itself to put reasonable officers on fair notice their use of force against Dean, again assuming his intent was to retaliate against Dean for headbutts and not to protect his safety would violate the Constitution. No, but nice try and all. In sum, the officers here were on fair notice of Dean's right not to be subjected to force in the form of pepper spray or a beating if that force was deployed for the purpose of retaliating against him after he was subdued and not for the purpose of officer safety, which is for a jury to figure out because they can figure out what the evidence does or does not lead to. For that reason, the officers cannot prevail on their alternative argument that they're entitled to summary judgment on qualified immunity even if they did violate his rights. Thus, that brings us to the end of the case of Willie James Deans versus Johnny Jones. In this case, we learned about a prison beating that occurred because the prison inmate likes the headbutts. His love language is headbutts. Unfortunately, the guards are just not into that kind of love language, and they prefer not being headbutted. The way they expressed that they would not prefer it, however, is a bit of a problem. They might have subdued the guy, which is perfectly fine, and then pepper sprayed him in the eye for 3 seconds, just out of pure retaliation, less so. And then they might have, for another headbutt, taken him into a closet and beaten the crap out of him, which there is some evidence to support that conclusion. The Court of Appeals says the trial court screwed up by failing to look at this from Dean's point of view, because that's a relevant thing for summary judgment. Now, there has to be a trial, and a jury will have to figure out what is true and what is not true. But there does seem to be some video evidence that would at least partially back Dean's story. And there is medical evidence that would partially support Dean's story. So it's up to a jury to figure out what was true and what's not true. So go back to trial, figure it out, and that is the end of the discussion of this case.